Welcome to Tuesday Night Live. You are at the Bellevue City Council meeting. It is Tuesday, November 19th, 2019. We will start with the Pledge of Allegiance, followed by the invocation. Assistant Pastor William Johnson from Revival Tabernacle Church will give us that. Please stand. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Well, thank you first, Mayor Hike, for allowing me to be here today. I count it an honor.
Welcome.
And I'd like to offer thanks to our police and our fire department and all of our emergency responders for keeping our city safe. Thank you. Let's pray. Precious Lord, we thank you for all of our city leaders here today. I ask special prayer for the divine protection of our police, fire department, emergency medical responders, and of course our military personnel. And Lord, please give our city council guidance as they endeavor to meet the needs of the community of Bellevue today. We know that a lack of guidance causes a nation to fall, but victory is won through many advisors. Lord, let us not be misguided in this meeting so that we do not lead to decisions that produce ineffective results. I pray that you direct our steps so that this meeting can achieve the best possible results concerning the needs of our great city. We place you at the center of all that we do here today. Amen.
Amen. Thank you, Pastor. Susan, roll call, please.
Mr. Stinson?
Here.
Mr. Cook?
Here.
Mr. Shannon?
Here.
Mr. Preister?
Here.
Mr. Burns?
Here.
Ms. Welch?
Here.
Thank you. All in attendance. This meeting is conducted in accordance with the Nebraska Open Meetings Act. A copy of that act is located on the east wall of the council chambers. Item number 5, approval of agenda, consent agenda, claims and advisory committee reports. 5A, approval of the agenda. Councilman Cook.
Thank you, Mayor. I'd like to move item 14A to right behind 7. I don't know if,
Okay.
with that change, I'd like to approve the agenda with the amendment just made.
Motion by Cook, seconded by Preister to amend the agenda, moving 14A right after agenda item number 7. Any discussion, questions? Please vote.
Are we gonna approve the amendment and then approve the agenda?
We can do it in 2 steps, that's fine.
Yes, thank you.
I'm sorry,
Okay, please vote.
And then we need a motion and a second to approve the amended agenda.
All voted yes.
Need a motion to approve the agenda? Councilman Cook.
I'll make a motion to approve the agenda.
Second.
Motion by Cook, seconded by Burns to approve the agenda as amended. Please vote.
All voting yes.
Thank you. Item 5B, approval of the consent agenda. Items marked with an asterisk are approved where this item is unless otherwise removed. Do I have a motion to approve the consent agenda?
Mr. Mayor, I would like to remove 5B1 and 5B2 so we can discuss those items.
5B1, 5B2.
And I'll make
The motion that we approve the consent agenda as amended.
We have a motion by Shannon, seconded by Preister to approve the consent agenda, removing items 5B1 and 5B2 to the regular agenda. Any questions? Please vote.
All voted yes.
Okay, moves us to item 5B1, approval of the minutes from the November 5th, 2019 City Council meeting. Councilman Shannon?
I'll make a motion to approve the minutes.
Motion by Shannon, second by Burns. Any comments or questions?
Yes, sir. This is a departure from our normal minutes. If you guys went through these, they're 14 pages long. So these are a lot more verbose than what we've been doing in the past. So my question is this to be the norm so that we stay consistent? Or is this just for a special occasion here? Or, you know, what are we doing here? Are we changing policy on how we do minutes?
There was a lot of there was a lot of comments last week, so do you want to answer that?
Yeah, I mean, I think it's within our rights and Robert's rule to do the minutes however the clerk deems fit that complies with the Robert's Rules of Order. They can be as detailed as possible. They can not leave out detail, but be less detailed if they want. And this is how it was drafted. It was reviewed by the city paralegal. I'm fine with it as well. I think because we had so many people speak at length, it was better to err on the side of putting more detail in these minutes to make sure that everybody who came and spoke, it's very detailed of what they said.
Okay.
It's not a violation of rules, policy, nothing needs
No.
to be changed.
No, I'm just asking if this is going to be our policy going forward, that we're going to stay this verbose.
I think that it's within the clerk's discretion to do the minutes as they deem fit, as long as it complies with the rules.
Okay, then I would ask that the remaining items that weren't included in the minutes be included in the minutes. We had the letter from the ACLU. We had the letter from the Nebraska Broadcasters Association. You had my letter back to the Nebraska Broadcasters Association. So if we're going to include the entire text of your speech, then let's include everything that was part of that evening.
Well, I don't think it's fair to say that it includes the entire text of my speech. It also includes statements made from several other members of the public and including yourself. And if you look on page 5, it specifically references the letters and the letters from you, multiple letters from yourself, opposition letters, letter from the ACLU, and Ms. Johnson's letter.
Okay, but the content of your comments are included. The content of those comments are not included. Same with Mr. Frederick. He objected to the fact that he just got a sentence and everybody else got a paragraph. But Chuck always objects.
What page is that on, Councilman Shannon?
I don't remember. I reviewed it a long time ago.
I mean, you can make a motion to amend the minutes if you...
I will make a motion to amend the minutes to include the items I mentioned.
Any further discussion, questions? We have a motion to amend the minutes as discussed by Councilman Shannon.
Question, Don?
You have to have a second.
I don't think we have a second, so I'm not sure I can comment, but I was gonna ask a question. They are referenced in the agenda for the meeting, and that's a permanent record, and they are then re-referenced in the actual minutes. So if anybody wanted, they're already there, and they're there permanently if anybody wanted them. So I don't know that we're missing anything. It's all there, and it's even referenced more than some things, so.
It's also my understanding that sorry, I didn't mean to interrupt, that the letters were also attached to the agenda on November 5th, so it's already all
Right.
a part of the record.
All those items have been attached to the agenda then?
They were all attached in November 5th, is my understanding, or referenced, and then clerk has them in their possession. But at this time, there's not a second to your motion, so
All right.
we can't really proceed.
Do I have a second? No, motion fails.
Okay. We have a motion on the floor to approve the minutes.
I think that's already been seconded.
Yeah, I second it.
Okay, it's still on the floor.
All right, any questions, comments? Motion by Shannon, seconded by Burns. Please vote.
All voted yes.
Item 5B2, approval of cancellation of the January 7th, 2020 City Council meeting and authorizing staff to pay bills that cannot be held over until the January 21, 2020 City Council meeting.
I'll make a motion to approve.
Second.
Motion by Shannon, seconded by Preister to approve. Comments or questions?
I saw one email on this topic, but I saw no discussion on it. We don't normally cancel a council meeting just because one councilman's gone. We still have city business to conduct, so I'm not sure what we're doing, and surprised it's here and on consent. But yeah,
It's been a long go ahead, Councilman Preister. You're long standing, so.
I'm just, the long standing, and standing is better than sitting for me. But I did send some information out about it. It has been the tradition, as it's described in the cover letter, that we have not met the second meeting in December, primarily because it gets close to Christmas holiday. And so rather than meeting then, we just have every year done this action. It isn't for a period of years, it's once for that year. We have not met, and we have authorized the bills to be paid. We're no longer that close to the Christmas holiday, which many people in Bellevue celebrate. So instead of that, we're now meeting the first Tuesday in January, and the first Tuesday in January then pushes our meetings to between 1 and 7 days from the New Year's holiday. And some days it could be the very first day of the year. So it seemed to me to make more sense in the beginning of the year when we have very few big agendas normally. I say normally because you say that and then something comes up. So this can be done year to year, and it makes sense to not conflict with the January New Year's holiday. So that's some of my rationale. I didn't get any other negative comments. I didn't get any feedback, and I didn't share it with an entire group for feedback. But if anybody wanted to individually respond to me, I did just get, I believe it was 2 comments that they thought it made sense.
okay.
And then just looking at the calendar, the meeting is January 7th. Usually our agenda meeting is a week before, which puts it on December 31st. And then we're out of, work days, New Year's. That's a holiday for the city employees. So just getting the agenda meeting going and getting everything on the agenda for the 7th as well. It's something just for consideration, timing-wise.
Okay. I guess we, back in May, changed our meetings to Tuesday to avoid this problem so that we could get the 2 meetings in December. And so, yeah, the logic of doing this, do we need to change what we do in January every year and go back to 2nd and 4th? So we avoid this problem every January?
I don't recall being changed to have 2 meetings in December. It was more or less.
It was one of the logics when we looked at moving from Monday to Tuesday, because that allowed us to get from 2nd and 4th to 1st and 3rd, and allowed us to get the 2 meetings in so we can conduct the city's business and not have a big lag time.
Yeah, I don't recall that piece of logic. I mean, it makes sense to a degree, but then also what Bree just said, even the 7th is the best we're going to do. So it could be the 1st, 2nd, or 3rd to have your agenda meeting. You're meeting on Christmas or New Year's. So it seems pretty problematic.
All right.
And if we have correct me if I'm wrong, but if we have a project, we can always have a special meeting for that. So if something needs to be done.
That's correct, Mayor.
All right, thank you.
Yep. Any other questions or comments? Motion by Shannon, seconded by Burns. Please vote.
All voting yes.
Thank you. Item number 7, special presentations. 7A, presentation on the branding and imaging initiative for Bellevue. Kevin Hensel, Bellevue Chamber of Commerce, and Dwayne Safarik.
Good evening. While he's signing in, my name's Dwayne Safarik. I'm of 203 Bellevue Boulevard South in Bellevue. Earlier this spring, at the spring planning meeting for the city and the budgeting and that type of thing, I brought to the table thought process of a community need that Bellevue needed a rebranding initiative to kind of refocus on the positive that Bellevue has to offer. And at this point, I felt that, and I appreciate your time, that it was time for an update to kind of give you an idea of the progress that has been made. I sit on the committee for this rebranding campaign, have been with it. We've been talking about it for about the last year and a half. So it's time to kind of start the action in process. So that's kind of what we're going to present tonight. Kevin's presented, or has a slide show to kind of kick it off, kind of show you what we're doing and what our time frame is for the future here.
Great. Thank you, Dwayne. Kevin Hensel, 14507 South 21st Street in Bellevue. So as Dwayne mentioned, this has been an ongoing project, and I'm a little late to the dance actually, and Dwayne is being kind of subtle. He's actually led this committee for quite some time now. So as an update, our objective here, really we're looking to solidify our community's vision and mission and communicate who we are as a community and what we have to offer as a community. We want a consistent, proactive message that conveys a sense of pride for our existing community and that also is attractive for new residents and businesses to come be a part of our community. So the Branding Initiative Committee is a diverse group of 17 community members that represent the City of Bellevue, the Greater Bellevue Area Chamber of Commerce, Sarpy County, Bellevue businesses, and businesses from the Omaha metro area. A request for proposal has been developed, and this has been a timely process and much back and forth and comment from the committee. A lot of work's been put into this document, and it is ready for release tomorrow, November 20th. Any marketing firm is going to be invited to submit. However, we have identified just over 20 local, metro, and regional and national firms who have done similar type of work that we'll be submitting this RFP to directly for their participation. And this is the RFP timeline. So submissions with the RFP being released tomorrow will be due back no later than January 17th of 2020. The short list will be announced. We will be identifying a selection subcommittee from our group of 17. The short list will be announced on January 31st, with oral interviews for that short list being conducted between February 3rd and February 14th, with final selection being made on February 14th. After that final selection and identification, then we will work to develop a contract with that agency to be completed by February 28th, and the contract beginning then on March 2nd. So our expectation that we will be back here with an update to the City Council, then the first City Council meeting in March to let you know who we have selected as the agency moving forward. So it's an exciting time, exciting that we've got some momentum and some movement on this project. Thank you.
Thank you, Kevin. Just one question. I'm on that committee. So are those early morning meetings done with at March 2nd?
Probably not.
Didn't think about it. So.
As Dwayne said, I said, "Oh, we've kind of hit the finish line," and Dwayne said, "No, we've just now approached the starting line."
So the anticipation is for, and what we've looked at as a committee is to be working with this process probably for the next year and a half to maybe 2.5 years. We're not going to rush the process. This is going to be in phases. So the first is to identify the agency and see what the ideas that are brought forward to work with. And then at that point, then we're going to work in phases, basically for funding as well as being able to present it to the community in a timely manner and get their feedback once everything's been identified. So it all is got to work together, but it's going to take a long time. And talking to some of the different people that we're going to be putting the RFP out to, that's kind of where we got the dates from as far as anticipated timeframes is about 18 to 24 months, and that's if everything works like it's supposed to.
questions, comments? Been a lot of hard work, so appreciate it.
Great. Thank you.
Just hang around for questions. We're going to open it up for public hearings. Oh, sorry.
We're moving to item 14A.
Oh, I'm moving too fast. Just stay right there, though. Your item 14A is moved up, and that is the public hearing on matters other than ordinances. 14A, approval of an event application for the Greater Bellevue Area Chamber of Commerce, Light Up Bellevue, City of Bellevue, for Christmas in Old Town on Saturday, November 30th, 2019, from 2 p.m. to 7 p.m. Actual event runs from 4 p.m. to 7 p.m. on Mission Avenue and Washington Park. Can you give us a little bit of what's going on there?
Absolutely. So we have our Old Town Christmas on November 30th from 4 to 7, as mentioned. The road will be closed. Franklin will be closed from Mission to Washington Park. The grand event will be at 6 o'clock with the lighting of the light spectacular by Santa and Mrs. Claus at 6 p.m. Event starting at 4 in the Firefighters Hall. We'll have Santa and Mrs. Claus available for pictures. We'll have kids' crafts and activities, cookies and cocoa. We will have live reindeer and a live nativity as well. And there will be food vendors lining the streets. I believe we have a half a dozen food trucks right now lined up from Mission to on Franklin, from Mission down to Washington Park. Again, then at 6 o'clock is the actual lighting ceremony. And it will be a great family fun event. Hopefully the weather is cooperative and we have a great temperature and a slight dusting of snow so that we can all get in the holiday spirit.
I got it pictured. Any questions before I open up the public hearing? No. Okay, now I'll open up the public hearing. Since this is an event, is there anybody here to speak for or against the event? Seeing nobody come forward, I'll close the public hearing and entertain a motion. Councilwoman Welch.
Before I enter the motion, I just want to thank a lot of the people that work behind the scenes on the Light Up Bellevue. I'm part of that group and haven't participated as much as I wanted to, but there are a lot of people working a lot of hours to get this thing done, and I just personally want to thank all of them for all the hard work that they're doing, specifically Joanna Hike for bringing this all together. So I'd like to make a motion to approve item 14A.
Second.
Motion by Welch, seconded by Burns. Any further discussion or comments? Please vote.
All voted yes.
All right. Thank you.
Great. Thank
you,
you.
Kevin. Dwayne.
Thank you.
Okay, moving on to 8, organizational matters. We have none. 9, approved citizen communication. None. 10, liquor licenses. None. 11, ordinances for adoption, third reading. 11A, ordinance number 3976, request to annex lot 37, Orchard Valley. Susan, could you read the ordinance, please?
An ordinance to annex to the City of Bellevue, Sarpy County, Nebraska, certain lands, lots, and real estate lying within Lot 37, Orchard Valley, to the City of Bellevue, Sarpy County, Nebraska, and designating an effective date.
Thank you. Motion, or Councilman Cook?
Thank you, Mayor. I'll make a motion we approve item 11A.
Second.
Motion by Cook, seconded by Burns. Any questions or comments from the council? Please vote.
I got to vote twice. Yes.
I've got yours still spinning. Okay. Oh,
So I did
must have canceled. All voted yes.
Thank you. Item 11B, ordinance number 3979, request to rezone lots 1 through 72 and outlots A through C, Bellago replat 1 from RG 50 PS and RG 28 PS to RG 8 PS with site plan approval in order to facilitate a townhome development. Susan, could you read the ordinance, please?
An ordinance to amend the official zoning map of the city of Bellevue, Nebraska, as provided for by Article 3 of ordinance number 3619 by changing the zone classification of land located at or about the southeast corner of 48th Street and Cape Hart Road, more particularly described in Section 1 of the ordinance, and to provide an effective date.
Thank you. Councilman Preister?
Thank you, Mayor. I will move to approve ordinance number 3979.
I'll second that.
Motion by Preister, seconded by Welch. Any comments or questions? Please vote.
All voted yes.
Item 11B1, approval of the preliminary plat. Councilman Cook.
I'll make a motion to approve 11B1.
Second.
Motion by Cook, seconded by Stinson. Any questions or comments? Please vote.
All voted yes.
Thank you. Item 11B2, approval of the final plat. Councilman Cook.
I'll make a motion we approve 11B2.
Second.
Motion by Cook, seconded by Stinson. Any comments or questions? Please vote.
All voted yes.
Thank you. Item 11B3, approval of the second amendment to the Bellago subdivision agreement for lots 1 through 72 and outlots A through C, Bellago replat 1. Councilwoman Welch.
I'll make a motion to approve, item 11B3.
Second.
Motion by Welch, seconded by Preister. Any comments or questions? Please vote.
All voted yes.
Thank you. Item 11C, ordinance number 3980, request to rezone lot 1, Southwoods, replat 3 from MH, BGH, and RG8 to RG8 for the purpose of an elementary school. Susan, could you read the ordinance?
An ordinance to amend the official zoning map of the city of Bellevue, Nebraska, as provided for by land located at or about Fort Crook Road and Childs Road West, more particularly described in Section 1 of the ordinance, and to provide an effective date.
Thank you. Councilman Preister?
Thank you, Mayor. I'll move to approve ordinance 3980.
I'll second that.
Motion by Preister, seconded by Welch. Any comments? Questions? All right, please vote.
Oops. Sorry, I did that. We have 4 yes votes and 2 no votes, with Mr. Cook and Mr. Shannon voting no.
Thank you. Item 11C1, approval of a conditional use permit for Lot 1 Southwoods replat 3. Councilman Preister?
Thank you, Mayor. I'll move to approve item 11C1, I'm sorry.
I'll second that.
Motion by Preister, seconded by Welch. Any comments or questions? Please vote.
We have 4 yes votes and 2 no votes, with Mr. Cook and Mr. Shannon voting no.
Thank you. Motion passes. Item number 12, ordinances for public hearing.
Leave 11C still.
Oops, sorry, moving too fast. 11C2, approval of a small subdivision plat, Lot 1, Southwoods, replat 3. Councilman Preister?
Thank you, Mayor. I will move to approve item 11C2.
I'll second that.
Motion by Preister, second by Welch. Any comments, questions? Please vote.
We have 4 yes votes and 2 no votes, with Mr. Cook and Mr. Shannon voting no.
Item 12, ordinances for public hearing, second reading. 12A, ordinance number 3977, an ordinance to amend section 2-28 of the Bellevue City Code pertaining to executive sessions. Susan, would you read the ordinance, please?
An ordinance to amend section 2-28 of the Bellevue Municipal Code pertaining to executive sessions of the City Council to repeal such section as heretofore existing and to provide for the effective date of this ordinance.
Thank you, and if the council doesn't object, I would like to open the public hearing for ordinance number 3977, which is 12A, and 12B, which is ordinance number 3978.
And 12C? No? Okay. Okay, just 12B1.
Yeah, 12B1's not really an ordinance, but it's kind of wrapped up into anything that would be fair game for public hearing.
So it's included, but it doesn't have to be.
Correct.
Okay. All right, so I'm going to open up the public hearing. Is there anyone here wishing to speak for or against the ordinances? 3977 or 3978? Councilman Preister?
Mayor, before the first testifier gives public comment, I'd just like to, for those who may be watching but haven't seen the packet, recognize the fact that we heard lots of testimony. This is the second public hearing, and that at that first one, in the current packet, there is a revision as of November 13th, a very close one, and that many, in fact, most of the comments were taken into account, and as many as possible have been incorporated into what would be an amendment. So if the testifiers would be aware that there is an amendment, and if they could give us testimony that helps us with that, that would be more constructive for us.
Thank you, Mr. Preister.
May I go ahead?
Yep, please
Thank
announce
you.
your name and
Thank you very
address.
much. Sarah Centennial, 1709 Childs Road East. I'm here again tonight to oppose this proposed ordinance. And I'm not going to revisit ground that we've already visited. Some of the amended, I did have an opportunity to read the amended petition, the amended ordinance. But unfortunately, it did not address some of the major flaws that I saw in the ordinance. And I also had the opportunity to kind of flesh out a new issue. So my first issue with this ordinance is the role of the city administrator and the investigative role. This, as described in the ordinance, really gives the city administrator free rein to decide whether or not something is with merit or without merit. And this includes accusations against the city council and the mayor. City administrator is paid by the city. He is not without a conflict of interest in this, and there would be a serious issue with transparency, and I believe it would look poorly to have an employee investigate an employer. This doesn't happen in the business world. It doesn't happen in the legal world because it's just a bad idea, frankly illegal, and would be challenged legally. This is the other question that has not been addressed at all is who has proposed this ordinance? I've asked this question many times and I have not received an answer. And I understand that's not a requirement of this council or of the mayor to disclose that information, but in such a contested proposed ordinance, if we want to go with transparency and we want to have integrity into the process, I think it is necessary for us to know who brought this ordinance forward and who proposed this.
Councilman Cook?
I'll answer it as far as I can for myself. I believe a few council members had expressed a concern that behaviors needed to be addressed and behaviors needed to be stopped. I know that I contacted them and we talked and had a meeting about it. So I don't know, if you want to point the finger at me, that's fine. But I'll throw my name in the pool and say, I know that I had contacted our administration and said, we need to do something. Would you at least investigate to see if there's something that can be done?
And so, and my question would be, did that effort fail then? You know, is there, when we get, because this is a drastic remedy for.
Well, I think for me, what it came down to was there was a state law. We looked at, I'm assuming what was looked at was cities of the first class. Is there any state law that would address this? And there was. And I think we have every right to take that state law to this level and try to create what I would consider, what so far I've seen is a very fair process. So, and I'm not an attorney, but I think if there's a state law there, I think we have every right to take that law and put it into an effect in our city. If people don't like the law, then we need to go to state senators and try to have that maybe rewritten or removed or changes made. I believe that law was put into place in about 1994. I could be wrong. And I think there's periodic reviews of them. I don't think there's ever been any changes. I don't think people got up in arms. I don't recall anything as far as when Grand Island or Fremont did it. I don't recall anything in the paper of people very upset with it.
And I think, and I'm sorry to interrupt, but I think, Councilman, that you misunderstood my question because
Okay.
I asked if you had tried other remedies to address, as a body, if you are able to communicate with each other, if there's other remedies outside of just this proposed ordinance in order to use your code of conduct to address those things instead of going to this what could be a very adversarial process. And I'm asking, my question was, were those things attempted?
I want to let Bree step in a second.
Can Councilman answer my question first?
I'm going to let Bree talk for a minute.
You asked who proposed it, and Councilman Cook answered your question, so I want to answer that question. And then you asked a question right before that I want to make sure I answer. And if we kind of break these down, we can make sure that all your questions are answered. So yes, we looked at the code of conduct. We looked at policy resolution 35 that was already in place, that already said that it is a violation of code of conduct if you do these things. But it ended there. What happens if somebody does violate the code of conduct? What happens? There was nothing that anybody could do because it wasn't put in an ordinance, it wasn't put in a policy resolution, so there was nothing that anything could be done. People could continually violate it and repeatedly do that. There could be letters sent, there could be conversations, and the actions continue because there's no ordinance and there's no policy resolution that accounts for a step further. And that's why we're here today. Can I ask you a question on the city administrator issue?
Sure.
You stated that you remain concerned about the role of the city administrator, that the city administrator is doing the investigation. Have you read the amended ordinance?
Yes.
Okay, where does it say that in the ordinance?
I'd have to pull it up on my phone and look at it, but it said something along the lines of the city administrator will receive the complaint that goes through the clerk. If it meets this criteria, it goes to the city administrator and they decide whether or not this deserves, whether it's a written reprimand, and then there's a hearing, and then after it passes through the city administrator, it goes to council.
Okay, I'm going to correct you because the amended version that's in the packet does not state that. What happens is that somebody can file a complaint, and she's pulling it up now. It's paragraph A, 1 and 2 on page 1. somebody can file a complaint. There's a checks and balance system in A1 that says that if you're going to file a complaint, it has to be timely filed. It has to be, and it says above that, it has to be in 60 days. So in A, it says you have to file a complaint within 60 days. So the clerk receives it, and the city administrator checks the complaint to make sure, one, was it timely filed? If people are filing things 180 days, 2 years later, no, if you have an issue, file it within 60 days. That is the only role of the city administrator. Confirming doesn't meet the timeline. Second, it says that the written charges were signed and verified. Because if you read A, we're asking that if you write a written charge that you sign and verify it. Because what we don't want to have happen is a flood of complaints against these council members that aren't signed, aren't verified, because that's an issue. So it's just the city administrator making sure that there's a signature and that it's verified. Paragraph 3, that if it's, A13, that if it, can you go up just a little bit? Down a little bit. A1 and then 3 in that paragraph. So that if it was filed by a citizen, because citizens have the right to file the complaint too, if it's filed by a citizen, that their address is listed in the written charge and that they are in fact a resident of Bellevue. Because if you look at A, we want to make sure that if people are filing complaints against city council members, that they live and reside in Bellevue. So again, the city administrator is just checking. Did they list their address in the complaint? 4, it says that the written charge specifically identifies misconduct. The city administrator is not doing an investigation. He's not determining whether it's misconduct. It's just a checks and balance system where if we receive a complaint and says, I don't like how Paul Cook voted because he didn't vote in favor of what I wanted. Okay, well, there's no need in having hearings. There's no need in having this big drawn out process for something that doesn't specifically identify misconduct. So he's just looking to see, does it identify misconduct? If those things aren't met, he's going to administratively close it as written. But if you go down to A2, can you scroll just a little bit? In red there, if he dismisses it, if he says this doesn't meet those requirements, not only is he going to dismiss it, he's going to email it or send it to all elected officials. If any member of this council decides, hey, I don't think it should have been administratively closed, then they can prepare a resolution, have it drafted, and you proceed on the rest of the ordinance. The city administrator is not doing an investigation. I just wanted to clarify that.
Okay. That, my apologies if I misread that. It was, he is still the gatekeeper, correct?
Yes, he receives the complaint.
So, my other issue, well, two other things. One is the definition of misconduct. It looks like the only, and I'm certainly, you feel free to correct me if I'm misinformed, the only particulars on misconduct are about discussions outside of closed session. Is that the only thing that's specifically included in this ordinance?
In 3977 or 39?
In any of the, in the proposed ordinance, it looked like the only thing that was detailed out was disseminating information outside of closed session. Is that correct?
In 3977, yes. In 3978, it references Policy Resolution 35, which was attached to the agenda, and Policy Resolution 35 is what then outlines additional misconduct. But 3977 only pertains to Code 2-28, which discusses the closed session. So that's kind of separate in that one, but it is readdressed in Policy Resolution 35.
And I was just wondering, because at the last meeting, Councilwoman Welch discussed issues of sexual harassment, and if that was included specifically in this proposed ordinance.
It's included in Policy Resolution 35 that specifically outlines the principles and conduct of decorum and any kind of misconduct. So yes, it is addressed in there.
Okay. Is it specifically mentioned? Because, and in the code of conduct.
It says the use of vulgar, threatening, abusive, or disparaging language or inappropriate sexual behavior or remarks or racial or ethnic slurs directed at the mayor, any particular member of the city council, any city official or employee, or any member of the general public shall not be tolerated.
So that brings me to my, the misconduct is still pretty broadly construed, and that is what it is. But the other issue is that this is not a judicial body. And so if you were going to have a hearing, I also, when we talked about Grand Island and Fremont and their ordinances, I asked this question before: have they had to use this ordinance, and how did that work out for them?
I'm not aware of that they've had to use it, but the ordinance has never been challenged. When it was implemented and passed, it was never challenged.
Has any city of the first class in Nebraska had to implement and use this ordinance in a trial setting or any kind of setting like that?
I did not call all the cities of the first class, no.
So we don't know?
The ordinances that I'm aware of have never been challenged.
And I'm not saying the ordinance challenge. I'm saying, has the ordinance ever been implemented in order to address the issues in this ordinance that are mentioned in this ordinance?
I think she's answered that.
That's not. You said the ordinance wasn't challenged. I'm not asking about challenging the ordinance itself. I'm asking about its implementation. How was it implemented in Grand Island, in Fremont, in any city of the first class in Nebraska?
And I believe that I answered that I'm not aware that they have actually had to use the ordinance. So I don't know that answer, but
so we
the
don't know what
ordinance
the
has never
legal,
been challenged.
Sorry. So we don't know what the legal challenges would be to that if it were implemented, correct?
I think you could argue that with any state law.
So yes. And
there, are you asking if there's case law supporting it? I mean,
I'm asking because the rules of evidence, if we're going to have a hearing, if we're going to have investigation, what rules of evidence are going to apply? Are you going to have subpoena power? Who's going to swear in witnesses? Are they subject to a subpoena? This body doesn't have that kind of power because it's not a judicial body. So the implementation of this ordinance is flawed from its outset.
This is not the room to argue that in. As far as I'm concerned, we're set up by state statute. We can do it.
And it's not a judicial body, so there's no penalty for perjury. There's no way to enforce witnesses to appear. And so there's just so many flaws in this system because you don't have any ways to enforce it.
Well, hopefully we'll never find out.
Why implement an ordinance you never want to use?
Ma'am, your 5 minutes is way past due, so we're going to end right there.
I recognize a dismissal when I see one.
Thank you. Anyone else wishing to speak?
Is it okay if I shut this computer down? Thank you. Good evening. My name's Michael Wills. I live at 1321 Harrison Street here in Bellevue, and I do live there. First thing, Ms. Robbins, thank you very much. You did a lot of work on this from what the original was and what the amended has been. I still have some questions, though. Unfortunately, I was not able to attend the last meeting because of another commitment. I'm talking about 2-28 right now. Is it still going to be misconduct if an individual who is in the closed session hears or sees and then goes out and discloses illegitimate or perceived illegitimate items that were discussed or worked on in the closed session?
If there's illegitimate, let me just answer those as you go. If there's
yes, sir, that's what I expect.
If there's something illegal happening, that does not stop.
It's happened.
That does not stop somebody from whistleblowing. Does not stop somebody from turning them in.
Okay, fine.
But there's no written exception in this either.
I'm sorry?
There's no
Mr.
written
Shane?
exception in this for a whistleblower.
It's already accounted for in state law. Under the Opens Meeting Act and the closed session, it already accounts for if the topic, when you went into closed session, there's a topic, a reason why you went into closed session. And if it expands, it's already accounted for in state law that you cannot be a part of that. And if somebody comes out and they report that the topic expanded, there's no penalty for that. That's already accounted for in state law. Same with whistleblowing, same with any kind of illegal activity.
Okay.
I don't believe it needs to specifically be addressed. If that's something we want to consider, we can absolutely consider that, but it is already specifically addressed in the law.
Okay, fine. Again, I'm not an attorney, never have said that I was, or anywhere close to it. I think I know the answer to this, but I'm going to ask it anyway. This ordinance, does it cover prior bad acts, or is it just from the time this goes into effect and going forward?
It's from the time the resolution goes into effect.
Okay, fine.
Yep.
What happens if a person who makes the claim of misconduct owns a house, a building, or other structure inside Bellevue, but their main resident, we have a state senator like this, who says, well, I own a building here in town, therefore I'm allowed to make this complaint. But my home is somewhere else. What about that?
You're referring to somebody specifically or some?
No. I'm just saying, this is open to anybody that wants to make a complaint. One of the things that it says there in this item is that, and now I'm on 3878, that the city administrator's job is to determine if the person lives in the city of Bellevue. What if they have a building or a house or something that they rent, but their residence, where they vote, where they get their mail, that sort of thing, is outside the city of Bellevue? Is that a disqualifying factor?
Can they still vote? Bree?
Yeah, that's a really good question. The ordinance states a citizen must be a resident. So if it's just a building, like an office building or something, I don't think that would qualify. They would have to be a resident. But whether or not they are a registered voter is not accounted for in the statute. That's something that could be considered moving forward, whether we want to confirm whether they are a registered voter at that address or whether they're just a resident.
Right.
So that's something we can look into. But then you also get into somewhat of, tenants and those sorts of things. It's something we can definitely consider moving forward.
I'm just trying to make people think right now.
I think that's a great question, so thank you.
Yeah, if they're a taxpayer, do we represent them?
Next one, Councilperson X receives some calls from people who want to bring up a complaint against Councilman A, but they tell Councilman X, don't use my name. I don't want to have to come in front of the council. Can Councilman X still make the complaint and these people be shielded from having to come forward, or will the council have a way of compelling these people to come forward?
So the council member could still make the complaint. So if it's kind of a secondhand complaint, they could still make a complaint, or the city administrator, if an employee comes to him and says something, he could still make the complaint. But it is set up in here to where the person who's actually complaining, so the one who received the harassment or the act was towards them, they actually have to appear at the hearing, because it is important that they have the right to cross-examine and confront the accuser. If they do not show up to the hearing that is scheduled, the complaint can just be dismissed.
Okay. The next one is, if a councilperson X makes a claim against councilperson A is not allowed to vote. Why is Councilman X allowed to vote? She has already said, I am against Councilman A, and that's not fair. Councilman X should be cut out of the voting process also.
Can I address that one?
Absolutely.
Okay. These are all
Please
really great questions. Thank you. there's a case, it's called Shear versus, I believe it's Wayne County, and it's an employment matter, but I do believe that if this is challenged in the future, that it could be equally applied in that situation. And in that case, what it says is that the person who brought the complaint against the employee was also the judge and the executioner. And that was fine, and it was okay in that case, and the Supreme Court decided that that was fine, as long as there are due process hearings or entitlements afterwards. So there would be appeal rights. If somebody is removed from office here, they would have a right to take that to district court and challenge that. Mm-hmm. And their due process would continue. So I do not believe that it's an issue to be able to be the accuser, the judge, and the executioner, and they actually use those three words in that case as well. And so that's already been addressed, and I do think there's no case law on point in this situation, but I do think it would be equally applied.
Okay.
Michael,
again,
I'm just
trying to make people think.
I would just add to that. I don't see where it would even matter if that person was able to vote, because all that person that has the complaint against them is looking for one person to side with them, because being removed from office requires a unanimous vote.
This goes all the way from the beginning of a written reprimand through and to include removal. I understand it has to be unanimous for removal, right? But to have one councilman who has brought, or person who has brought a problem about another council person, then it just doesn't seem fair to be able to. But you've addressed that, so moving on. This is just very procedural, Ms. Robbins, and you'll be able to answer this one for me, I know. A written reprimand and the oral reprimand, are they kind of like censure, or are they type like Congress has a censure that doesn't really mean anything? It just, hey, we don't like you.
Well, I think the verbal reprimand is, the written reprimand. Let me get there really quick. Yeah, the written reprimand is going to be something, so it's set up to where after the hearing, there's going to be an original vote on whether or not there was misconduct. Because if there's not misconduct, then you don't even get to the next phase. So if there is a vote that there is misconduct, then there would be a separate motion to apply one of these sanctions.
Oh, I thought the way I was reading this is that we went, and I think a lot of other people may have gotten the same mistake, that the first time out of the box, you're not going to throw somebody off the council. You're going to get a written reprimand. If you do it again, we're going to get you out in front of the public and give you a verbal reprimand. Then we're going to remove you from, if you continue to do it, we're going to remove you from your being on committees or seniority. And finally, if you're really an idiot, we're going to remove you.
It is set up that way, so it's the progressive sanctions. So. And it states in here that the council is committed to do progressive sanctions, but there would still have to be a motion on whether that's a written reprimand or whether that's removal from a committee, if that makes sense. But they're all committed to doing, and it says that in the ordinance, the progressive sanctions. So
that's what I thought. Mm-hmm.
You would start at the written reprimand. And a written reprimand, so there would be a finding of misconduct, and then there would be a motion for a written reprimand, a second, and then a vote. And the written reprimand is going to be something that's really kind of done then behind the scenes. It's going to be, here's your written reprimand. It's not a public reprimand, so they're not entitled to see what it says. Okay. Although it's a public record, so you probably can get it.
Now, suggestion, I think that the council president, unless he or she is the individual being charged, should write that letter. And also, if it comes to a public reprimand, that's the person who should do that also, just to keep it going in that same way. Let me see if I've lost my place. No.
I think that's awesome.
Going back to 228 for just a minute. Sorry for this, but
I'm being lenient on my time just because it is important, but just keep.
These last two points are important, I think. A person who sits in on a closed session, who can they talk to? Their wife, their spouse, their children, their extended family? And let me tell you why. Because if, let's say, we have a problem that's in closed session and all at once a senator ends up putting in a bill in this legislature down there at the unicameral that directly, the only way they would have known about it is if it came out of closed session. So are we allowed to, not we, I'm not council person, but are the council people allowed to talk to, or the people that are in those closed sessions, talk to it? When I was in the Army, and I know it's not the same thing, but if I got need to know information or top secret information, I couldn't tell my wife, I couldn't tell my children, I couldn't tell anybody. I think the same thing should stand here.
Can't be discussed outside closed session. That's the rules.
Okay, great. One last item. There are things that are may be brought up that are sensitive in nature, very sensitive in nature. And the one that comes to mind is sexual harassment or something of that nature. The way our world runs today, the presumption of innocence is kind of thrown out the window as soon as somebody says anything sexual. I would like to see that the accused have the right to a closed session for those type matters. Not for everything in the world, but just for those. And now I don't know if we can do it, but that's it.
Okay, just real
I
quick.
can answer that really quick.
Okay, great.
It's not specifically addressed in here. I think at any time the council would have the right to go into closed session. So if there's a motion to go into closed session on that, or if the accused is asking, the council members can consider that, make a motion, vote, and those items could go into closed session.
Thank you.
Thank you very much for your time.
Thank you.
I have a question for Bree. On one of the things Mr. Wills brought up, you said there's appeal rights to a decision. So if there are appeal rights, then declaring a seat vacant shouldn't occur until after the appeal rights expire.
No, pursuant to statute, if you're removed, you are removed and it's vacant forthwith. That's how it's set up in statute. If you wanted to challenge that, or if somebody wanted to challenge that in district court, you could file something in district court and proceed in district court, but the vacancy would happen immediately. And that's set up already in state law.
And if you win in district court, then you could be replaced into your seat and that someone else has already been appointed to?
That's how it's set up, yes.
Okay, that's odd.
Good evening, Council. My name is Jim Modry, 1207 Rebecca Court here in Bellevue. And it's a beautiful day today, wasn't it? Really was. I've been asked by the Sarpy County Republican Party Chairman, Nora Sandine, to read a letter into the record. Before I read it, I just want to let you know this was voted on November 7th in our meeting, so it was before the latest amendments came out and were posted, and they weren't on the 13th. Policy 35 was on the 13th, and the other one was on the 14th, and they weren't posted until late afternoon of the 15th, so for the public to see. So some of what's in the letter has already been taken care of, but I want to read it for the record so it gets in the record.
So, Mr. Modry, this is the letter, the same letter that
Yes.
the council received?
Yes.
Okay, thank you.
Yes. Okay. From the Sarpy County Republican Party, Nora D. Sandine, Chairman, to the Honorable Bellevue Mayor Rusty Hike, with copies to each of the city council members and to the city administrator. Regarding proposed amendments to the Bellevue City Ordinance number 3978 and Policy Resolution 35. The Sarpy County Republican Party is in strong opposition to the proposed ordinance in Bellevue, which will usurp the power of the citizens of the city of Bellevue to elect and remove their council members. The laws of the state of Nebraska allow for the recall of local elected officials in the state. The people have the right to elect their officials, and with the separation of powers enumerated in our system of government, the people have the right to recall their elected officials or remove them from office at the next election. Although state statute may allow, and the word may is in the statute, may allow the city to remove a council member, we do not believe that usurping the power of the citizens of Bellevue is the right thing to do, and is contrary to Robert's Rules of Order, which the City Council is required by ordinance to follow, which allows removal by a permanent body, which is the people. In addition, this ordinance could be interpreted as an attempt to silence members of the council who disagree with the mayor and/or city administrator, and would allow the city administrator to administer discipline to a city council member via written or verbal reprimand. This is contrary to Robert's Rules of Order, Article 72, which states that it is the inherent right of a deliberative body, in this case the city council, to make and enforce its own laws and punish an offender. City council members are elected by the people, are not employees of the city, and do not work for the mayor or city administrator. Therefore, they have no right or authority to discipline city council members. That is the right of the council and the citizens who elected them. We urge members of the council to stand up against this attempt to seize the power of the citizen to elect their representatives, hold them accountable, and to vote against them in the next election or recall them. It is not within the power of a single branch of government to remove someone from office. Instead of removal from office, the city council could institute an ordinance that would give them the power to sanction members for misconduct. That misconduct should be well defined so that members of the council and the citizenry would know the distinct guidelines. We respectfully ask you to consider carefully the action you take, that it is within the law and reflects the point of view of the citizens of Bellevue. Please place this in the written record of the Bellevue City Council. Respectfully submitted by Nora D. Sandine, Chairman, Sarpy County Central Committee. And she asked me to read this in as a member of the Central Committee and as a member of the Executive Committee for the party.
Thank you, and accepted into record. I do want to just have, since Bree responded to that letter, I would just like Bree to touch on it as well.
Sure.
Thank you for coming and reading that. We did have the opportunity to receive that last week, research a little bit more after that letter, look at Robert's Rules of Order. I also want to thank you for the feedback that we received from you. You sent really good feedback on some suggestions for revisions. I went through those very thoroughly, and I really appreciate that and your testimony at the last hearing, so thank you for that.
A lot of those were incorporated. Thank you.
Yes. And in response to the letter, you stated in there a couple of times that it's the right of the council, and you stated it's not the right of the city administrator. And I agree with that. And how it was originally written, and that was before that redraft got sent out. There were things in there that did give the city administrator some power. That has all been removed. It's all the city council, which is the elected body. I had the opportunity to review Robert's Rules of Order. My amazing paralegal over there did extensive research on this as well. We do believe that it is in compliance with Robert's Rules of Order and the state law. And I'm confident after reviewing all of that and reviewing that letter that it is in compliance. But it was very helpful to be able to look at that and read more in depth to make sure.
Can I respond to one thing
on
Robert's
absolutely.
Rules? There is a section in Robert's Rules that talks about the right of a permanent society to remove a member. Then it says, but it has no right to go beyond what is necessary for self-protection and publish the charges against the member. In a case where a member of a society was expelled and an officer of the society was expelled, an officer of the society published by its order a statement of the grave charges upon which he had been found guilty. The expelled member recovered damages from the officer in a suit for libel, the court holding that the truth of the charges did not affect the case. So there's just maybe perhaps a legal concern there if those charges are published, which the way things are written, they would be. So, okay. Can I speak a little bit on my own behalf now?
A little bit.
A little bit. Okay, thank you. As I said, the state law that was mentioned earlier says a city of the first class by ordinance may provide for the removal of elective officers of the city for misconduct. So it's not a shall. The law does not bind you to doing that. It's something the city can elect to do. Just wanted to make sure of that. In Policy Resolution 35, and Bree, when you read this one section a little earlier at paragraph E, you left out a word that I also have objection to. I don't know if that was intentional on your part, but it says the use of vulgar, threatening, abusive, or disparaging language. You left out disparaging.
If I did, I apologize.
That's a word that I would like to see left out. Disparaging language. Just a comment there. There's also throughout, if you're going to go ahead and pass this throughout Policy Resolution 35, needs a little cleanup on some punctuation and a missing two in the last sentence of paragraph C and some other items throughout. Okay. Okay.
Councilman Preister, well, Jim's thinking there.
Yeah.
Mr. Modry,
Yes.
since you've already done the research, I had noted a couple of those things, but if you've got others, thank you. Could you forward those to legal counsel to just?
Yeah.
I know you're concerned about efficiency and time use by the taxpayers, so that would help.
Absolutely.
Thank you.
Well, I'm leaving on a trip tomorrow morning to do a oral presentation, as was mentioned with the RFP earlier. I have one that I have to do an oral presentation on, but so it'll be in a couple days.
I appreciate that. Thank you.
I'll scan it and get it to you. Okay. You know, my objection, I think, is with removal from office. With Robert's rules, an organization where that organization itself elects its members, elects its own officers, decides who's going to be a member of that organization, it's perfectly fine and dandy for them to be able to remove a member. In this case, where it's the members of the city council are not chosen by the city council, they are elected by the citizens. And I just feel that it is the right of the citizens to be able to remove them. I totally agree with the sanctions, you know, verbal reprimand, written, all those kinds of things, and I think that gives adequate transparency to the actions of a member of the council or of the mayor. And citizens can use that information then if they want to recall that person or just not vote for them in the next election. So I see that as kind of a big difference in how Robert's rules is applied for most organizations versus an elected body that doesn't approve its own membership, doesn't elect its members, doesn't elect its leadership like other organizations do. So I think that's it. Thank you.
Thank you, Mr. Modry.
Yep.
Public hearing still open. If there's anyone else who'd like to come forward?
Evening, everybody. Matthew Barrows, 909 Hopkins. There's a lot of what's already been said is kind of what I was going to say. But I just wanted to put my name down here, let y'all know that I don't agree with this. Some of the sentiments that have been spoken about tonight, you all aren't convincing me, and I feel like that's the way it should be. I'm part of the people. Y'all work for me. Y'all work for them. There's a lot of people opposed to this, and I think that should give you pause. You shouldn't be smiling, shouldn't be laughing. This isn't funny. This is very serious. And as someone with a political science degree, and I studied a lot of law myself, A lot of justices came before, a lot of Supreme Court justices came before. You cited a Supreme Court justice case. A lot of the thought is you shouldn't just look at what you're doing now, but how can it be used in the future? How can it be developed? And I think somebody mentioned it's kind of the state of affairs that we're in right now in this country. And I think it's something to really consider. A lot of people have said that we're in a cold civil war. And sometimes I think that's true. To where party lines, we're just not the same people we were. And we should really give pause. And you should really consider yourselves and consider your own seat. I just really want to say, I think it's really sad that we need to do something like this. I think it's really, really sad and pathetic, quite frankly. The fact that you need to do this, and there hasn't been transparency as to why this has come up. The nice woman here asked that question. Obviously, you have a problem. You're not talking about it, but obviously you have a problem because this wouldn't even be on the agenda tonight, right? So that's sad. It really is. We're adults. We can't act like adults. We can't treat each other with respect and dignity. We have to come up with some law that gives you the power to remove somebody from office. We started our meeting with a prayer. Can we not love each other like we love ourselves? We can't do that. We can't treat each other this way. It almost brings me to an emotional state that I even am seeing what I'm seeing. And I just wish you would really give this more serious thought, especially with all the objections, as to how this could be used to damage someone permanently. That's it.
Thank you.
Good evening. I'm Brian Hanson, 2704 Georgia Avenue in Bellevue. I spoke at the last council meeting on this topic and had a couple questions. I did look at the packet. I have no life other than looking at things. There are voluminous pages of information. So I guess it was more curious of what was changed and what wasn't. The first comment I have is the gentleman before me spoke about having this confined to residents of Bellevue. And as we know, and tonight we see lawyers and attorneys and other folks representing business in front of Bellevue. Their offices may be in Omaha. They're an Omaha resident. I would amend that to read Bellevue residents and or anybody having business in front of the council, because if they have an item and they feel that they're not getting a fair shake because of some behavior or lack of behavior, I don't see a reason why they shouldn't be able to bring it up, not sour grapes in the fact that they didn't have the thing go their way, but because of a thing. So I think that's definitely excused. We also have people in the 3 mile jurisdiction that this council imposes rulings and directives on and ordinances on, and while they're not a city resident, they certainly have business and a vested interest in that. So I think that would be a pertinent amendment. I looked at the ordinance 397778 and the policy resolution. I see executive sessions spoken about, and I was kind of unclear about the verbiage. But as we know, not only are elected officials invited to executive closed sessions, there are also appointed folks, city staff and others, and I don't really see a consequence or a result if they happen to be the leaker or discloser from that session. So I think that needs to be addressed. You also have folks who might be in that same executive session who are under labor or union agreements, and certainly I don't know if there's supposed to be consequences levied from this. As I read 3978, it says removal of elected officials. So I guess that would be only those officials who are elected by the voters and not city staff or not appointed staff. Is that correct?
Yeah, that's correct. And any misconduct that would apply to an employee is already accounted for in either our union contracts or our employee handbooks. And we have information in there that you can't disseminate confidential information that you gained during your employment, those sorts of things. So there would be internal reprimands or whatnot, like we would in a normal employee case, if those things were violated by an employee.
Okay, thank you for that clarification. And I kind of assume that would be the case. I would hope that that would be a little bit more elaborated. And then as I read policy resolution 35, that applies to everybody. Is that sort of a good generalization? I see you nodding. And so I think that's the same issue there, is it talks about consequences for elected officials, but what about other folks? And one more step back on that is earlier in the year, and I don't, everybody here's been that, but you have words like impertinent language, and you have other things, and specifically, obscene was pulled out of the briefing card that the mayor reads normally when they used to have the public session to speak up, because it was the ACLU's opinion that, ALCU's opinion that it's a free speech issue. So that was specifically pulled back out of that briefing card. I don't know if the paper ordinance caught up to that or not with speech. I mean, am I going to stand up here and say the F-bomb? No, but I said because it's being polite and courteous and all those things. But again, it's, there's means and procedures if somebody wants to do that, to have me ejected from the meeting and maybe dismissed or barred from that. So
and some of those words have been removed in policy resolution 35, impertinent, profane, inflammatory. Those things have been removed from policy resolution, the last amendment.
Okay. One other thing I didn't see in this grouping of ordinances is if the people who are involved with it, i.e. the city attorney and the city administrator, as far as staging this proceeding or whatever, if they're somehow have a conflict of interest and stuff, what are the process and procedures for replacing those folks in these roles and making sure things happen? Along with that, it's a possibility you have an even number of council members, perhaps two are involved in this, so you're down to a four-person voting block, and you've got 2 and 2 split. Who splits that vote? Is that the mayor to split a tie vote on other elected officials? I think that gets into a gray area that nobody should be getting into.
Well, and I think we talked about this. I think Mr. Wells brought this up as well. The person, if I'm just going to pick on Mr. Stinson really quick, if he brings the complaint, it's not set up to where he would have to abstain from the vote. And that goes back to that case where the Supreme Court has decided that he could be the accuser and then ultimately the judge and the executioner. So I don't think that situation would apply. But certainly if there's a complaint against me, or if I'm bringing the complaint, I do agree that it would be very hard for me to then be a witness and question and cross-examine everybody in the hearing. And we already have internal procedures for that. If there's a conflict of interest with me in like a case that I take, if a case comes in or we're sued and there's a conflict of interest, we contract that out with a different attorney. So that could be something where another attorney would absolutely have to come in here and do that, because I wouldn't be able to be a witness and question everybody. And I could look at that and see if there's a way to rework that in the ordinance as well, so it's addressed.
I would suggest more is probably better in this case, since it's such a drastic and final means of doing things. One aspect of this that I kind of look at an earlier incident this year is we had a member of the council who had property condemned via ordinance, et cetera, after some things. And it was struck me as very weird that this person had to, one, step down from this part I don't have a problem with. They had to step down from their seat on the council, but they had to exit the entire room. I would think that that person should be able to sit in the audience if they so desired to hear what goes on and reference their particular issue. That to me is weird. I mean, and I don't think it's really right either and stuff, but I think that to this. So you have the same sort of scenario here. Would they be able to, and you said can answer the affirmative, that they'll be there for most of these parts of things, but I think we have a real incongruity when an ordinance affects somebody for their real estate property, but yet, and they have to exit, but here they're allowed to stay. And I think those two things need to be trued up and made to align with each other. Personally, I'm still against it. I kind of echoed what Jim Modry read from it's a drastic measure. It's something like that. 100 years from now, will we ever hear of anybody having done this? I don't know, but I still think it's a pretty drastic measure when we do have recall and we do have petitions for recall, etc. Thank you for your time.
Thank you. Public hearing is still open. Somebody coming.
Good evening, Council, Mayor. Bill Baldwin, lifelong resident, City of Bellevue, currently a resident of Ward 1. Got a whole list of notes. I was attending the last meeting. There's been a bunch of stuff covered tonight already that really doesn't need to be said again, outside of a couple things, I guess. I think the word transparency is really a tough word to be using within your guys' position in relationship to the taxpayers, and what you're trying to do is become transparent or be transparent. Transparency to me is something that is required from you guys, not something you strive to do to prove to me. That should be a given, because we've put the faith in you to vote for you guys, to bring you into office. So I really don't believe you guys need to demonstrate your transparency. It just has to be expected, if you understand what I mean by that. In listening to, I know Ms. Centino and a couple of the others with the judicial side of this, you guys sure you want to become that part? I know I wouldn't think you'd want to be both ends of this, because it certainly looks like it's set up for failure to me. I would think any grievances within yourselves, you should be able to solve. I mean, you are our taxpayers' elite. You're our voters' elite. We voted you guys in. You're supposed to represent us the best way you can. And if we're going to fight amongst themselves, or if we can't get along ourselves and figure things out amongst ourselves, then we need to turn it over to the police or the or the jurisdiction, the legal parts of the system, rather than trying to do it with the legislative part of the system. I just don't see that where you guys really need to bring yourself into that. I know this was asked before, and it's also been asked again tonight. And I think Councilman Cook did make an attempt to address it. I don't think it's been addressed yet, but I'm going to bring this word back out again, and it's the word I hate, and that's transparency. Where'd this get driven from? Where'd all this come from? I mean, we've gone years and years and years and years without having an issue. I shouldn't say that, because I am going to bring up a deal where we did have an issue. My note says, who upset the apple cart? Anybody care to reply? I mean, something's driving this. Something is driving this issue now. It's not just something that, oh, Grand Island and Fremont are doing it. Why don't we? Okay.
Mr. Baldwin, we've had multiple.
Pardon me?
We've had multiple council members tell us to end this problem. So it's not one person. And Mr. I can't remember, I didn't write your last name down, Barrows. He said it's terrible that we have to come to this
It is.
decision.
It is very.
And I don't
it's
think
sad.
It is sad.
It's sad that we have to, and I would think as a body as yourself, you should be able to pick, find, and correct those problems. And if it is a legal problem, then it goes through the legal processes, not through you guys.
And the statute gives us that legal process. Now, you say if one of us council members, if the other 5 council members think they're doing something drastically wrong, they're representing 5 wards. They're representing the voters. I would want that person out if they were doing something that bad.
I think that's where it comes back to where it becomes a public knowledge, and it's going to be public knowledge because unless it's behind closed session, it's all public knowledge anyway. So whatever's going on, if it's going on, hasn't become public knowledge yet. As you talked about the numerous incidents, at least if they are public, I've not seen anything yet. If they're minimal enough, I would think they should be able to resolve within the body itself. And if not, take further legal action or whatever action needs to take place.
And can I respond briefly to that? Do you have a suggestion on how that can be handled internally among themselves? Because it's something that I came in here and I was asked, hey, is there anything we can do? Because we've tried, we've talked to people, we've brought it up, we've sent letters, and it's not just one person. And it's not just this council, it's happened over a number of years. And they've tried all of that. Everybody's tried all of that. But when you have an ordinance and you have something set up to where it doesn't matter how much you try, it's never going to be corrected because there's another step, the behavior is never going to be corrected. And so you said, then take the next action, take the next legal action, and that's exactly what we're doing. And I can assure you that things have been attempted, even in my short time here. I've only been here since February, and I have witnessed things tried to be attempted, discussions had, and actions continuing. And there's nothing that anybody can do without a consequence, without a sanction. And we are taking now that next step.
Maybe something that could be looked at is if it can't be resolved with the council president and the rest of the council members, that it be brought to a citizens advisory. 5 or 6 citizens on a timely matter, not something that's going to drag out. If it's something that can't be resolved, they say, hey, let's meet with our citizen advisory committee. We'll come back with how we want to proceed next week or the following week.
I think you have your citizens advisory committee voted in here by the people. So I don't know how it gets any better than that.
Well, outside of the fact that it appears to be some conflict of interest to me, and I'm just speaking as a voter, citizen.
I totally
to be
understand.
A conflict of interest to me.
We're looking for solutions.
I'm going to go one more thing. I've got some other notes here, but I'm going to go the last thing. Or I do want to talk one more thing. There was something that happened years and years ago. Some may remember, some don't. But there was a problem with some council members, and they were disciplined for some credit card issues. I don't remember all the details of it, so I couldn't even come close to see how that was handled. I believe there were some legal actions. I don't believe they were removed. I think they were removed by the voters at that particular time. I believe that's the way that played out. Okay, one last thing, and this is probably the most important to me as being a taxpayer. Is at the last meeting of this meeting, I've not heard one person come up here for this motion. I mean, everybody that's been up here has been against. And I mean, there's been some very, very prominent people up here. A lot of government officials, city officials, ex-current, city of Bellevue or Bellevue school officials. And man, if that doesn't get the point across somewhere along the line, it really needs to. I mean, it really does need to, because like I say, I haven't heard one proponent.
There has been one, and it was Mr. Richards, who's been on the commission. He's a lobbyist in Lincoln for OPPD, so he understands it. He did come out and support. I don't know. I can't remember if there's any others. But I can tell you, I am out in the public. I talk to a lot of people, and when people come up to me, they say, "I sure hope you get that ordinance passed." And it's multiple people. Nobody comes up. Now, the people that don't want it are sitting right here.
Well, I come in, I put my time in, so I've done what I can do. I appreciate you guys listening to me.
That's so funny. You think I'm lying back there? Somebody laughing?
I do think it's funny because I think that it's interesting that you would say that only the people.
All right, you can't speak. Sorry, I spoke to you.
You addressed.
I did. I'm sorry. I'm
Okay.
gonna shut it down.
Let me. One last comment, I guess. I thought it was pretty rude of how Miss Centennial was treated. I mean, there's probably another way that could have happened. I mean, she was maybe beating a dead horse there a little bit that you didn't want to hear, but it could have moved on to others. Okay? Thank you guys for your time.
I don't know what you're speaking about there. Miss Centennial was mistreated here?
I thought it could have been treated differently.
Could I just briefly
rather than
address
just
that?
telling her she was out of time.
Yeah, I appreciate all of your comments and feedback, and I made multiple notes. I thought you had a lot of really good ideas. With Ms. Centennial, she did come at the last meeting, and she repeated everything that she said at the first meeting. She is also an attorney and was addressing me in that capacity. And so that's why I had a little bit more of a frank conversation with her than everybody else. And if she was mistreated, I apologize for that. I do not think that she was, and we've already addressed those questions.
Thank you.
Thank you. Thank you, guys, girls.
6 speakers, 1 hour, so I guess I'm giving everybody 10 minutes. Is there any other speakers like to come forward?
Leanne Gifford, 10111 South 11th Street. So I'm the one person tonight who's in favor of this. I do want to make clear, and I'm sure that the council understands, that the removal portion of it is an extreme measure that should only be used in extreme circumstances. As far as people saying, well, there's been no transparency, what's driving this? It's like, you know what? If you listen closely, you can figure it out. Last meeting, Councilwoman Welch said that she had been the target of some sexually inappropriate comments. Mayor Hike asked some questions which got me thinking there's somebody who is making comments, perhaps being bullyish about it, perhaps being outright harassing about it, and has been told through letters, through phone calls, emails, all kinds of conversations, stop. And it doesn't stop because what's there to stop it? And I say him because if it's a council person, we know it isn't Ms. Welch because she's the one who said she was a target. So it's one of you guys. The problem is if this is being directed to an employee, the employee is getting a cause of action under the Nebraska Equal Opportunity Commission, under the Federal Equal Opportunity Commission. You're putting the city of Bellevue at risk, exposing the city of Bellevue for financial damages if an employee is being targeted. When a council person is putting the city at risk financially, I think that's a point when, yeah, they need to be removed. If they come out of an executive session and tell people, oh yeah, we've got this company X, they're gonna come and they're gonna put up, you know, a big plant. I mean, in Pottawatomie County, we had a code name for a company that was coming. And it took a while before anybody could say Google. It was probably several years that all that was being planned behind closed doors, quiet discussions. That continues on in all kinds of counties and states where you have to be quiet because you can't let a competitor get an edge. Or you can't let a landowner know someone's looking to buy that and they need a lot of property, and you know what, yours is at a prime spot, because all of a sudden the landowner's going to say, I'm going to be charging a lot more. They're really going to have to pay a lot if they want my property. There again, somebody who comes out of a closed session and gives information that should have been kept quiet is now costing the city because there's a company that didn't come, didn't bring jobs, didn't bring more tax revenues to the city. Those types of actions, I think removal is warranted. Now you can say, well, you've got the recall. The recall is difficult. It's expensive, it's time consuming, and what if it doesn't work? You're stuck with the person, you know? There has to be a way of getting rid of a liability, and that's why I'm in favor of this. Thank you.
Thank you. And just to add to that, I would, and I'm talking to the council as well as the public, I do expect some big things coming in front of this council in the next 12 months, and we cannot have people talking about it, period. Public hearing is still open.
Mr. Mayor.
Mr. Mayor, may I ask one question? I forgot to ask.
Go ahead.
You might be able to answer it. I thought I read in the amended ordinance that the attorney would have to be paid for or supplied by the person that's being accused. Is that not does that not go against due process? Like, shouldn't somebody be able to get counsel if they're being charged with something and facing removal of office?
If you're,
that's my question.
Yeah, no, that's a great question. If you're charged with a criminal complaint that warrants a jail sentence, you have the right to an attorney under the Constitution. This isn't a criminal case and there's no jail sentence, so you don't have any constitutional right to an attorney. And it would be the same in kind of any employment matter. They can get an attorney, and most of the time those are either paid for by the union or they're paid for individually by that employee. That was a great question.
Thank you. Public hearing is still open. Is there anyone else that would like to speak?
Mr. Mayor, I've got a couple of citizen inputs that they've asked me to read in. They're short.
I'm gonna go ahead and close. Is there anybody else that would like to speak? Please come forward now. Okay, seeing no one, I'm gonna close the public hearing. Councilman Shannon?
Okay. The first one I had was from Chuck Frederick. He's not able to be here, as you all saw. He's not doing well and getting around. So we wish him and his wife the best. Chuck says, when I spoke last meeting, I suggested you vote no on the resolution because, like I said, there are two mechanisms to replace a city council person. One is voting the person out, the other is the recall petition. When you have 8,000 to 10,000 people vote you in, there's no way 5 people should be able to vote you out. This is not a banana republic. I'm not sure that this is legal, but even if it is, it sets a really bad tone for what Bellevue is like. The majority of people don't want this, and I predict whoever votes for it will not be reelected next time for office. Chuck Frederick. Then I have another email, and I'll tell you straight up, 100% of my calls and emails are going against this. Nobody understands what this is about. This individual, Raymond Pierce, he's a student of the Constitution. He brings up some interesting points, and I learned some things out of this that I didn't know. So he says, in the United States, the citizen is sovereign. Our rights do not come from government, but from the Creator. The most basic right is the right to vote and to elect our representatives. The greatest amelioration to those of the political class that perform misdeeds is a free press that investigates and reports. With this in place, the procedure for a recall would come in play. Bellevue lacks a legitimate newspaper. His opinion, not mine. The executive should not appoint and the council confirm a replacement for the council, as the council is directly elected. Directly elected, for those of you that don't know, is a concept that the framers of our Constitution wrestled with, okay? And they stuck with that, all right? It may be said that governors have the right to appoint a person to a vacated Senate seat, but this is because senators were not directly elected until the early part of the 20th century. Until that time, the senators were elected by the state legislatures, and the governor's power to appoint a person to a vacated Senate seat is a legacy. Governors have never had the power to appoint a person to a vacated House seat, as they have always been directly elected. The correct procedure for removal of a council person not being recalled should be as follows. And again, this is his opinion. He says, a unanimous vote by the 5 council people not candidates for removal. The case would then be referred to a district judge. The candidate for removal would have the right to have the case heard in chambers or in open court. The candidate for removal would have the right to legal representation at city expense. If adjudication results in removal, a new election shall be held within 60 days, not business days, calendar days. The person removed would retain the right to run in the election unless precluded by law. People wishing to stand for election would have 20 days to file. Irrespective of how many people ran for the vacated seat, the person with the most votes would be the winner, and if the person removed wins the election, he or she would be immune from the remainder of their term from the removal process. This would codify separation of powers, the right to due process, and salient of all, the right of the people to directly elect their representative. Those are good comments. Bob, you asked for the floor?
Councilman Cook?
Thank you, Mayor. I want to make one quick comment, and then I got something I want to read that I prepared. One of the gentlemen here, I think was, sorry, I forgot your name, Matt, maybe, said it was pathetic and sad that we're at this point, and it is. It is absolutely pathetic and sad that we're here. We have some hurt employees that have been disrespected, and it's very simple. It's 2 words: stop it. Whoever's doing it, stop it. We won't be here. We could have left an hour and a half ago. But I want a restatement. Ordinances 3977 and 3978, along with the proposed policy changes to Resolution 35, have been discussed and will be voted on at our next council meeting. As an elected official, each of us is expected to conduct ourselves in a professional manner at all times. We are voted into office by the citizens of our community, and it is our responsibility to represent our constituents in a respectful and professional manner. An elected official, whether on the council or as a mayor, we attend council meetings, meetings with directors, other city employees, the city administrator, and also hold executive sessions. Topics discussed in executive session could revolve around potential real estate contracts, personnel issues, and other sensitive information. At no time should anyone in attendance of an executive session discuss the subject matter outside of the closed session. At this time, there are no consequences for anyone who may share sensitive information with someone outside. There is no rule to follow because each of us are elected to our positions. We do not report to the city administrator. Therefore, he has no authority to reprimand, discipline an elected official for inappropriate behavior. Because the information discussed in executive sessions is sensitive, we cannot let public know when someone has breached that confidentiality. With no recourse at this time, an elected official is free to do whatever they choose without any fear of consequence for any inappropriate actions. These ordinances are not only to address information being shared in executive session, but they are a means to have some form of consequences for elected officials who would behave in an inappropriate manner by using vulgar language, bullying, threatening comments, name-calling, making sexual innuendos to city employees. Without these ordinances in place, how does the city address hurtful, harmful, disrespectful, discriminating comments by elected officials? Being timely should be our goal, and it is the most effective way to handle these issues. These ordinances are the most timely and effective way to address these matters. An elected official should not constantly and continuously make threatening and harassing comments to or about our employees. These comments have included name-calling, lying to, threats of physical violence, being argumentative, use of vulgar language, intimidation, manipulation, disrespectful, and sexual in nature. An elected official cannot release or discuss information from an executive session. And an elected official should not disrupt our meetings with hurtful, harmful, disrespectful comments. An elected official should not state to another elected official, I should backhand you simply because you disagree. An elected official should not make a comment to a city employee that if you do that again, I will put my effing foot in your effing word A, referring to rear end. because they disagree. An elected official should not talk about a city employee saying, if they weigh 300 pounds and most of their weight hangs to their knees. That was said to a female. An elected official should not make a comment to an employee using vulgar language regarding her attire and sexual innuendos. And an elected official should not make a comment to an employee, you should watch out, I just had my testosterone shot. An elected official should not make a comment to a city employee, you have had a lot of boyfriends, you know how to blow, referring to the employee blowing out her candles on a birthday cake. Our city is at a point where something has to be done to protect our employees and the city from these types of behavior. No one should have to worry about sexual harassment, threatening comments, or inappropriate behavior being directed at them. These ordinances clearly state there are steps before an elected official would be considered for removal unless it is a very serious and significant issue. This is not something we take lightly. However, there have been many instances of such behaviors, and there is nothing at this time to address how to handle these situations that were mentioned. If there is a better way, as your representatives, to timely, effectively address these behaviors, we're open to suggestions. I think we had a lot of those discussions tonight and 2 weeks ago, and a lot of the things that we talked about were put in there. By passing this ordinance, there is the potential consequence for any elected official who uses their position to try to intimidate, harass, or threaten another person. We are entrusted to vote to make the best decision possible based on the information we are given for each agenda item brought before us. We do not take our responsibility lightly, and each of us should represent this city with the highest level of integrity and professionalism. If this ordinance is passed, it will hold elected officials accountable to their actions. Thank you.
Thank you, Councilman Cook. Any other comments?
Maybe just briefly. I just have a couple quick things. I just wanted to confirm, and I think I said this at the last meeting, but I did speak with Frank Daly with the Accountability Commission. We reviewed the statute, and he confirmed that he doesn't see any issues with it. He has reviewed the recall statutes and doesn't see any issue as well. I also spoke with Lash Chafin from the League of Municipalities, and they work with municipalities all across the state. We reviewed this together as well, and he confirmed that there is no issue with it. I will confirm that several of those statements that Mr. Cook identified have also been reported to me, have also been heard by me, and that's why we're here tonight.
Thank you. Any other? Councilman Stenson?
I'm going to change what I was going to say here a little bit. After Councilman Cook read his paper there, I'd just like to make a motion that we reopen the public hearing to see if that changed any thought process out in the audience.
Second that.
Motion by Stenson, seconded by Burns to reopen the public hearing for additional comments if somebody would like to make them. Any comments, questions? Please vote.
No.
Yeah, mine disappeared.
All voting yes.
Okay, the public hearing is reopened regarding ordinance number 3977, ordinance number 3978. And if you want to talk on resolution 35.
Hi, Jim Modry again. I just have one item. A lot has been mentioned about things happening, remarks to city employees and so forth. Many of those city employees, I don't know many, but some of the city employees are not residents of Bellevue. And according to the ordinance, would not be covered in the initial screening.
I do think that's a great point. I do think I set it up, and I'm just confirming. In section 2-208A, if it's a written charge filed by the citizen, then they must be a resident. And if it's filed, hold on one second. Yeah, if they're filing it as a citizen, they have to be a resident. But if they're filing it as an employee, then that's not an issue. And I can clarify that in here if that would be helpful. That was the intent of that.
Okay, thank you.
Back. Let me clarify. I was not for, nor am I against this ordinance. I was just trying to bring up some information. Let me go on to say, I put almost 25 years in the Army, and I will tell you, the Army has some really bad language at times. But I have never around women or civilians ever heard some of the things that President Cook brought forth this evening. I'm not allowed to say in public what I think about those people, but they're deplorables. Absolutely. They do need to go. One question for you, Ms. Rump. Actually, two. One, real quick. It says in there that if we go to past 10 o'clock or it's 10 o'clock and then we're going to cut it off, how are you going to let the community know how much time is going to be? Because, for example, we run to 10 o'clock tonight, cut it off. Are we going to pick it up tomorrow at 6 o'clock? That's not enough time to let the community know. It's got to have at least a week.
They have the ability to make a motion to continue it. It happens a lot in city councils, Sarpy County, their boards do it. If there's something that runs over or if they want to address something at a different time, because of meeting time constraints, they'll make a motion to continue it and set it for a time. So that would be an option. Another option would be to then set it for a different special hearing, do the notice, those sorts of things.
Yeah. Well,
so I think that would be...
We just need enough time to let the public know, because it says notify the public. You can't just hold it in 24 hours or 48 hours. That's
Absolutely.
all.
Thank you.
And I want to talk to you afterwards.
Okay, perfect.
Thanks.
I would like to take this opportunity to address Rusty, since I wasn't able to do it from the audience since you addressed me from here. So why I laughed is because you implied that the only people that oppose this ordinance are the people that showed up tonight, and that's simply not true, and that there's no data to back that up. As far as the issues with sexual harassment and what has been said allegedly, just because we don't know, it's terrible. Like, nobody should ever be spoken to like that. Why it's gotten to this point is something that really needs to be examined. Why the public doesn't know that there's an elected official that we put in office speaking like that is a failure of the system.
Right, Mayor. I would just like to comment too.
Yeah.
And Sarah, I'm not disagreeing with what you're saying. I was a police officer for 3 decades, and we know sexual assaults, especially when you get to misconduct, most people, they are never reported. They fear retaliation. They're concerned about their job. If you have a person working here and that's their income, and these comments are being made, I think you would agree with me. Most of those are never, ever reported officially, like to a boss or HR. People just hear them. They don't like it. Life goes on because they don't want to lose their job. They don't want to be retaliated against and stuff like that. And let me clear something. The examples that I gave tonight, I feel confident if I did that in my job, one of those things I'd probably be terminated. 2 of them, I don't know where I would land when they threw me out, okay? What I said tonight, the examples I gave tonight, were said by one person, okay? And those people have either, from the comment that Bree said, she's either talked to them, the person that the comment was made to, or someone that was in the presence heard it and told her about it. Okay? So I want you to understand is that I didn't go out soliciting people, hey, has anything happened? It's things that are being told, and either the person that the comment was made to or the person that was present and overheard that comment, Bree has talked to or communicated with.
Not all of them. Some of those happened before my time, but
Okay.
they were reported up through the channel.
Well,
So I just
let
wanted
me
to clarify that.
rephrase. A couple of the other comments either happened to a city council member that I'm personally aware of, or I was present when the comment was made. So either she has heard it, or I've heard it, or we've been victims of it, or whatever, okay? So it's not secondhand, third-hand knowledge from other people. It would be from a potential witness or the person the comment was directed to. One of those people would be fired. All the comments that I started with I should backhand you, down to, you had a lot of boyfriends, you know how to blow. A comment made to a female employee blowing out birthday candles because I'm assuming a group of co-workers were sort of celebrating a birthday party. Those comments, either one of us have talked to the person as a victim telling us or as a witness telling us.
I am certainly not saying that I don't believe you or believe that
what
that
I'm saying,
happened.
but I just wanted to respond to you because we know that most of these behaviors are not reported.
Right.
They are never reported out of fear and retaliation. And I can tell you from talking with administration, there has been attempts to stop it, talking to people, putting some documentation down. There has been attempts to stop it, and all those, like I said, everything I said came from one individual, and it won't stop. And I would almost say it has gotten worse.
So my question is that what do we have in place at the city level for city employees in order to handle, like, what kind of workplace education do we have? How do we teach our employee? I worked at a hospital for years. I would put good money on you could look around at all these adult women in this room, and every single one of us has been victimized at some point in that, and that's just a fact of our world. What we can do is empower our employees and make sure that we empower their supervisors and their bosses to protect them. I don't know the specifics. I certainly, my focus is this ordinance. I think it's not that these things don't exist. I agree that these things exist. When this ordinance first was brought up, it was because it was items were spoken outside of closed session, and this is a different issue. I understand. I totally understand it, and that's what I'm saying.
Sarah, I believe that we have the steps in place that will allow an employee to go to the level that they would need to report something like this. I'm telling you, these things don't get reported.
Sarah, can I just add to that? So there are mechanisms in place for them, or I should say they are empowered to report those. They are trained well on that. The problem is we don't have a mechanism to correct it. So as you said, it's a failure of the system, and that's what they're here tonight to discuss, is to correct that system so they have a mechanism to modify or correct the behavior or take the next step. That's really the only interest here, is to modify the behavior.
I think that the goal is admirable. I think that this is the wrong tool. This tool is quasi-judicial. This body doesn't have the judicial power. It doesn't have the power that we don't have the evidentiary rules in place. It opens up the city for lawsuits, and for whoever eventually, if that person is removed, they could very well claim that they file a lawsuit. And as far as employment law applying to law of a duly elected public official, those are not the same thing. Those rules don't apply across the board. Employment law does not apply to public officials because they're not employees. I looked up the case. It is not on point on the facts. So while I admire the goal, this is just the wrong tool. And that's all I have to say about that.
Thank you.
Thank you.
Good evening, Brian Hanson again. I'd just like to commend Council President Cook for his statement. Some of us, quote unquote, the public, and I'm speaking only for myself, one of the biggest things I raised last week and this week is I didn't understand the impetus for this. I mean, where did it evolve from? What's causing this cauldron to boil up and go? So I would like to thank Council President Cook for his courageous statement, and there's certainly a need, and I'm reevaluating my own position based on what he said. I wish I'd heard it a week earlier, but you know, it's good to hear it tonight and stuff. If you know, of your perceptions and your observations.
It was very tough to do, okay?
Say again?
What I just read was very tough to do. And I wanted to do it just to be basic so that I didn't point out anybody. It's all of us sitting up here. There's 7 of us as elected officials. But it was, how do you say it and how do you get it out? And you were right. A couple of you said, what's going on? Who's pushing this and why? I'm to the end of my rope. If my wife came home or whatever and said, I'm sitting at my workstation and here's what a council person or a mayor just said to me, it'd be reversed. I'd be out there and they'd be throwing me off the council. Okay, now I shouldn't say that because I don't encourage.
You'd probably be in the chief's
anything.
Custody with your hands behind your back.
The point is, it's hard to talk about this. You got to realize
Absolutely.
that people that came up and gave it, how much has really occurred? How much of this has actually occurred? I gave you 5 or 6 examples, not examples, of things that have occurred. So if 5 or 6 occurred, you could probably say statistically that very few of this is reported. Could this have occurred 30 or 40 times? I don't know. And I'm not accusing anybody of doing it. But these have been brought, either I was present, I was aware of it, or I was told about it. Okay? I feel very confident on what I said, and I think I touched the tip of the iceberg.
And
It's
my
got
thanks for
to
stepping
stop. And it's simple. Look at all 7 of us up here. Just let's say, stop it. And if it stops tonight, we'll never have anything to worry about.
Thank you.
Public hearing still open, if anybody else wishes to speak.
I'll just say a couple things. I'll continue. Everybody seems to be continuing on the motif that they left off on, so I'll do the same thing. I'll say, from the heart, the mouth speaks. And whoever you are, you really need to check yourself, because that's some nasty stuff. These are women. These are daughters of God. And these aren't just average women that are in this room right now. These are women that are getting out and getting after it. They're smart, they're educated. Not that anyone deserves that, but thank you, Councilman, for saying that, because I was really quite confused as to what was going on here. I still want to echo the sentiments of the lady behind me that this to me is kind of like a red flag law. It's going a little too far. I wish there was a way that we could come up with a solution that doesn't involve such an extreme measure. I just wish there was time to come up with something a little bit smarter. And I will say, since we're in the holiday season, It's a Wonderful Life, great movie. And there's a scene in there where George Bailey gets knocked upside the head for saying something to somebody's wife. Maybe if we had some old school justice, we wouldn't have this problem. That's all I gotta say.
Anybody else wishing to speak? Okay, I will close the public reopening hearing, whatever you call it, on ordinance number 3977, 3978. Any other comments, questions from the council? Councilman Burns?
Well, I'd like to say, regarding what Councilman Cook has said, I don't condone any of that behavior. Do I think any of that's okay? No, it's not. Do I think that there's really good intention behind this? I really do. I think that there is a flip side to each coin. I think that there's always good and there's bad. And looking at it long term, I think that the council members up here today, if we're looking 10 years into the future, it's going to be a different council. We're going to have a different city administrator. We might have a different mayor. That's changing. But I guess my question is what is wrong with the election process and letting citizens make that that decision, you know, deciding who they trust in office and out of office. Does someone want to answer it?
I think Ms. Gifford probably gave the best behind that. A recall election, it's hard to organize.
Mm-hmm.
It's expensive. Getting that message out is really tough. You as an elected official have signed up to represent 8,000 people. Each one of us have. You're representing those people. I don't see anything wrong with it. You're speaking for your people.
And I understand
That's a unanimous vote. If you can't find one, if all 6 of you want me off here, if I can't find one person that wants to keep me, I'm leaving. I don't even want to be here. I shouldn't be here.
Mm-hmm. I understand that. Thank you. Even with that being said, again, I don't condone any of that. I really don't. But I really think implementing an ordinance that allows for removal of an elected official from this body is poor public policy. Removing any elected official from the office she or he holds shows a lack of faith in my constituents and the rest of the citizens within Bellevue. I do plan on I intend on voting no. But I think the difference between the election process or a recall process is the fact that people actually have that decision instead of us making that decision unanimously. Thank you.
Councilman Preiser?
Thank you, Mayor. I appreciate what Councilman Cook said, and I applaud his courage in saying it. I know it wasn't easy. I know it wasn't easy for some of these women to have experienced it. And I appreciate the people who came up and acknowledged that that was totally inappropriate. I also recognize that other things have happened and they have not been spoken. I recognize that this is the extreme. We should not be here. I couldn't agree more. But we're here because for years these things have gone on. They are inexcusable. And yet, it wasn't that many years ago that these things happened constantly to women. And what's good about this discussion is it's raising the elevation of how we treat women in our society. And for some men, it's still okay to abuse them, to misuse them, to mistreat them, to use all kinds of language in front of them, and to bully and intimidate. That way of operating in society should never have occurred, but it certainly shouldn't keep going on. And when we as a council are aware of it, and when we try to honor personnel rules and not disclose things outside of a personnel process, we are frustrated. We have no recourse. We have no opportunity to address any kind of consequence. Laws aren't made for those who are law-abiding. Laws are made for those who break the law. And consequences need to be imposed when those things happen, is how we as a society have determined we operate. If we as a council cannot discipline our own, cannot do things internally, then how is the public even supposed to know the full extent of what's going on, and how are they even supposed to vote on somebody? And talk about a recall election, it's mentioned how costly it is. You've got to get the word out, and you've got to let people know about it. In any election, you have to have 35% of the number of votes that were cast in that particular race. Let me go back. The requirement of 35% for the last mayor's race was 16,323 votes cast. 35% of that, you have to go out and you personally have to find 5,714 people to sign a petition to even get a recall started. Then you have to go through a recall election. And after the election, nothing may happen because the people never even heard the things that actually happened. This is an extreme measure. We're frustrated And we have been trying and talking and talking and talking for years and getting absolutely nowhere. And I agree with Councilman Cook. It's gotten worse. It has not gotten better. What are we supposed to do? We've asked for input. We've asked the public to tell us more things without consequences, without serious consequences. This will only continue. And because it can happen at other levels and has even happened at a federal level, it emboldens people to do more. That's not right. Women, employees, we deserve better. Bellevue can do better. And we as a council need to set the tone and the example. We need to discipline our own internally. And if you look at the paper, almost every day, this from a recent paper, exploring moral mathematics, morals. People are calling for us to be moral people. Developing trust in business, just one addition. Everywhere you look, you go to our schools and the kids are saying, be kind. They're setting the example for us. When we have, and these are just minor things about being kind, those statements go far beyond being kind. We need to set an example. We need to set the tone. We need to deal with these issues, and we have been trying, I assure you. And thank you for listening. I also want to mention that all of those things pose great financial liability to the city of Bellevue. I would feel that I was derelict in my duties if I allowed that kind of violation to continue and that kind of exposure to financial and other liabilities to the city of Bellevue. I do not intend to continue doing that when I keep giving a second chance, a third chance, a fourth chance, a fifth chance, a sixth chance, and it goes on with no change in behavior. I apologize if that was a rant. It was my feeling. I did speak from the head and the heart, and that's exactly what this ordinance and policy is intending to do, to take serious action for extremely serious methods that have happened. Thank you.
Thank you. Any further discussion, comment? Councilman Stinson?
I don't want Councilman Burns to feel like the lone wolf out here. I spoke about this last meeting. I do not agree with the things that are being said as far as I believe what Councilman Cook has put out in front of us. But I can't believe that those kind of comments are actually made to people. They're uncalled for, and nobody deserves to be talked to in that way. That being said, I too feel that I like the ordinance up to the point of removal. I think we need to figure out some way for the people to find out about this and take it from there. The people should vote the person out. They voted them in. And the process that goes with that, if we give them the verbal warning, we give them the written warning, if there's public hearings on that, the people start finding out about these problems that they're having. And then when it comes time for removal, or if it even makes it that far, once the people find out that these type things are being said out in public, the recall is probably going to already start. So with that, I'm with Councilman Burns. I can't vote for this ordinance. I would like to, if we could get the removal from office out of there, I would be more than happy to vote for this ordinance. But we've got to figure out another way to remove them than to have the council remove them. The public needs to do it. They voted them in. Thank you.
Councilman Shannon.
I'm going to be with Councilman Burns and Councilman Stinson on this. I too agree with everything that's been said, but I can't support this. The electoral process is the core of our democracy, and we have to respect it. There's no way I can support this with removal in it. There's good things in it up to that point, but with removal in it, You're not going to get our votes. Thank you.
Any other comments? Questions? I didn't realize we were voting tonight.
We're not voting tonight. Oh, that was a joke. Sorry.
We have 2 more weeks to make up our mind, and I don't see any reason that we have to decide tonight. But obviously, there has been decisions made. Third reading and vote will take place December 3rd, 2019 at 6 p.m. here in the council chambers. So with that, I'll go to 12B. I'll read the ordinance and have Susan read it. We've already done the public hearing. 12B, ordinance number 3978, an ordinance to amend Article 4, Chapter 2 of the Bellevue City Code by adding a new section 2-208 regarding removal of elected officials for misconduct. Susan, would you read that ordinance?
An ordinance to amend Article 4, Chapter 2 of the Bellevue Municipal Code by adding a new section 2-208 regarding removal of elected official for misconduct and to provide for the effective date of this ordinance.
Thank you. That public hearing has already taken place. Any further discussion by the council? Third reading and vote will take place December 3rd, 2019 at 6 p.m. Item 12B1, approve amended policy resolution 35 regarding principles of conduct and decorum. There is no action until action has been taken on the prior ordinance. Item 12C, ordinance number 3981, an ordinance to redefine ward boundaries due to recent annexations. Susan, would you read that ordinance, please?
An ordinance to amend Section 9-3 of the Bellevue Municipal Code to provide for revised city council ward boundaries, to repeal Section 9-3 of the Bellevue Municipal Code as heretofore existing, to provide for the publication of this ordinance in pamphlet form, and to provide for the effective date of this ordinance.
Okay, I will open ordinance number 3981 up for public hearing. Look who's here.
I'm back. Brian Hanson, 2704 Georgia Avenue. I live on the north side of Georgia Avenue, and I have a question and clarification. Am I to understand that the new boundary is going to run right down the middle of Georgia Avenue, west from 25th Street to Cedar Island?
Yeah, we'll defer to Tammy, and if we need to bring Mappa up here, we can.
As I read the verbiage, it tends to imply that, so it's basically, as I read it now, it's dividing a street into 2 different council wards.
That's why we have public hearings.
We have 2 of our MAPA officials here this evening. One of them is Josh Corrigan, the GIS specialist that helped assist in the legal descriptions and the map. So maybe Josh could come up and clarify, but also if we could have the map pulled up, please. Thanks.
And I'll go ahead with, if it is indeed down the middle of the street, the Georgia and Alberta Avenues, the first increment of Sunrise would move to Ward 5 from Ward 4, and the Georgia Avenue South to the second and third increments of Sunrise would remain in Ward 4. And I think that unnecessarily divides the neighborhood. We're trying, obviously, the first, and I group together the second and third increments aren't as unified because of the way the streets run. But I think that's not desirable from my point of view as a resident for 25 years in that area to divide a neighborhood that way, and perhaps another scheme could be devised to make those ward boundaries different.
Thank you. I'll have Josh come up. And just a general comment on that. There are numerous subdivisions that will be divided at certain points just because it has to be, but there might be some minor adjustments. I'll let Josh.
Yeah, so just to clarify, you're correct. Where that ward is divided along the street, you will have people living on either side in a different ward. We used streets primarily to do the divisions, so that will happen throughout the entire ward structure.
Thank you, and I would echo my opposition to dividing that subdivision that way. Thank you.
Thank you.
Hello, Sherry Fletcher, 11807 South 53rd Avenue. So I'm a new resident of Bellevue effective November 1st, and I object to the way that you are dividing our neighborhood. If I'm reading the map correctly, straight down Moss Road, so the older section of the neighborhood will be in Ward 2, and the newer section will be in Ward 3. And I know you were trying to make populations even. I know that was part of the goal. But I really object to pulling off one section of our neighborhood into one ward and the rest of the neighborhood into another ward. We, echoing his comments, we try to be a unified neighborhood. I don't think that council members are necessarily have the same mindset from different wards, and I think it's more beneficial to a neighborhood to all have one representative.
Thank you. And we have, that was one we discussed. Ward 2 is a very difficult ward to structure. It always has been for some reason. It's always had some weird lines to it.
Stay true to our council members.
And the other thing that we have to do is keep our current council members within the ward that they're in.
Oh, that's only if they admit to live where they're actually representing.
Is that right? So it's a big problem.
Yeah, well, I'm gonna tell you I'm opposed.
Okay, thank you.
Michael Wills, 1321 Harrison Street. If you could bring that back down so you can see Ward 4 for a minute, please. The white area that's in Ward 4, is that going to be up for annexation along with, because I live there, that's why I'm interested in that. But the rest of this white area, is that going to be incorporated and therefore we're going to have to readjust the wards again 2 or 3 times next year before the election?
Yeah, just to let everybody know, the wards, when the census comes out, we will probably have to redo the wards. So
But,
they're going to be redone anyway, probably in 2 years? Or
yeah, in
2 or 3
2021.
years.
Mhm. After the census comes out, 21, 22.
And nothing would be done after this vote prior to this next election. Pursuant to statute, it has to be a certain time frame. So whatever is approved by the council on December 3rd would not change prior to this next election.
Okay, but that area, again, why I'm in Ward 4, are you going to, is that something that we can annex, and why haven't we annexed?
Yes, it is. It's just they're newer SIDs. The bonds are pretty high on those yet, so it doesn't make financial sense to bring those in yet, but they will at some point. And I don't know if MAPA has accounted for maybe leaving that ward a little bit light on numbers to
Well, I'm not,
cover that.
I just wanted to know if yes or no, and I got that. Yes, thank you.
Now I have another question. So you said these won't take effect before the next election. So if that's the case, then all of us who are new residents, who are we voting for?
This will take effect prior to the next election. I think Mr. Wills was concerned that it could change again prior to the election.
Got it. Thank
So this will be effective.
Thank you.
Public hearing on the ward boundary changes. Anybody else want to talk? Seeing nobody, I'll close the public hearing. Councilman Preister.
Thank you, Mayor. Josh, if you would come back up to the microphone again, and if you would please state your name and who you represent and sign in also so we have that for the record.
Of course. So Josh Corrigan, I'm with the Metropolitan Area Planning Agency. I am the GIS coordinator there.
And as you're signing in, I won't get too much into it because sometimes when I'm trying to concentrate on writing, I'm not concentrating on hearing. So I don't want to confuse myself or somebody else.
All right.
At least in Ward 5, in the written description, it is extremely clear. When you use street names, people can look at it, and as we've heard tonight, you know exactly where the boundary is.
Mm-hmm.
But when you start at the Papio Creek and you go down Harrison, that's clear. When you come up 25th Street in Ward 5 that I have the privilege of representing, all very clear. When you finally get down to the southern part of Ward 5, it says from the existing city limits. Now, an average person isn't going to have a clue where the existing city limits are at that location, and it would lead you easily to believe that it's straight down Cornhusker back to the Papio Creek. But in fact, that's not the case. And even in reading this, I'm not sure if the Calvary Christian Church is in, if part of the Tree, Shrubs, and More is in. I assume it's just between Tree, Shrubs, and More and the corner properties. But even somebody who has experience, I can't tell where my boundary is. And I'm told that the election commissioner goes by the map and not the written. But if somebody looks at the map, they're going to go to the written to try and sort it out. And how do we clarify so there's no ambiguity in where those boundaries are?
Sure. And in a perfect world, every line would be straight and we'd never have to worry about, the ambiguity issue that we deal with. I took the existing structure of your wards and used that language to develop these. So I was trying to iterate and keep things, in the same flavor that you currently have, to make that change not very extreme. One thing I considered when looking at this area, and we could maybe add here, it says you go west when you reach that boundary. We could also say it goes south and west. There's room for us to add that language, which would, when someone reaches that point in the description, imply to them that we're now traveling, south of Cornhusker. Would that be enough to
I think that
clarify?
would help because right now it doesn't look like you even go south of Cornhusker, and in fact it does. And there are no streets back the way this goes, so you can't use streets.
Right.
I get it. It's tough. Redistricting is always tough, and that's why we ask MAPPA to do it, so none of us are gerrymandering or doing any other things that we can be accused of.
Mm-hmm.
We're trying to do it to stay contiguous, to keep communities of interest together. But when you're bound by state requirements, federal requirements, to have virtually the same population, I think we have a variance of maybe 5%. We're pretty limited in what we can do. But
true.
At least in mine, I'm aware of that area, and I think what you're suggesting would be helpful.
Great. I will make that change.
Okay. And I don't know if anybody else has had a chance to drive or check theirs, but I did mention it to everybody in case they wanted to.
Thank you.
Thanks.
And for the council members, please do look at those before next meeting, close as you can. Is there anybody else? Did I close it? No. Is there anybody else that wants to speak? All right, I'll close the public hearing on 12C. Third reading and vote will take place December 3rd, 2019 at 6 p.m. Item 13, ordinances for introduction. First reading, we have none. Item 14, public hearing on matters other than ordinances. Oops, sorry. We did that one earlier. Item 15A, approval of resolution number 2019-39, approval of resolution authorizing the mayor to sign the year-end certification of city street superintendent form for 2019. Councilman Cook.
Thank you, Mayor. I'll make a motion we approve item 15A.
Second.
Motion by Cook, second by Burns. Any comments or questions? Discussion, please vote.
All voted yes.
Thank you. Item 16, current business. 16A, approve the acquisitions, permanent and temporary easements for the 36th Street Improvement Project in an amount not to exceed $60,175. Councilman Cook.
Thank you, Mayor. I'll make a motion to approve item 16A.
I'll second that.
Motion by Cook, seconded by Welch. Any comments or discussion? Please vote.
All voting yes.
Thank you. Item 16B, approve and authorize the mayor to sign the CDBG grant agreement and funding approval for fiscal year 19, funding for $355,531. Councilman Preister?
Thank you, Mayor. I move to approve item 16B.
I'll second that.
Motion by Preister, second by Welch. Any comments, discussion? Please vote.
All voting yes.
Thank you. Item 17, administration reports. Are there any comments on them? Questions? Okay, we'll take those into the record. There are no closed sessions, so does anybody want to adjourn? Councilman Burns.
I move that we adjourn.
Second.
Motion by Burns, second by Preister to adjourn. Please vote.
All voted yes.
Thank you.